Good day, Crime Talk aficionados. It is Saturday, June 18th. What does that mean? It means a weekly recap of the top stories throughout the week, conveniently located in one spot, right here. I hope you enjoy it. Thanks for watching, and we'll see you next time on Crime Talk. First, Lori Vallow, Chad Daybell. Well, the court has issued an amended order for Lori Vallow's trial date. That will now commence in early January of 2023. If you'd like to hear further discussions about why that could be problematic for the prosecution, if there's an issue on speedy trial, you can look at the previous videos that we've done on that case. But what is the issue today? Well, it's an interesting little development. There have been several motions that have been filed by the defense in this particular case for Chad Daybell. We've got motions going back to May 20th, a motion on May 24th, May 25th, June 1st, and June 6th. And I said to myself, why is it that nobody wants the public to know what the heck is going on? So one of the first motions to seal filed by the state was the state of Idaho puts forth before the court a motion to seal its motion to deny defendants' motions without a hearing due to failure to comply with Idaho Criminal Rule 12 for the following reasons. One, the interest of privacy as predominant over the public interest disclosure based upon the motion filed in response to the defendant's motion were filed under seal. Sealing said document is the least restrictive measure consistent with the privacy interest at issue, and sealing these documents during the pendency of the criminal investigation is the best interest of justice. Whew, that is a lot. Okay, so then I go back and try to figure out, well, why are they so interested? What is the issue that is being put forth? And the motion keeps coming back as it relates to motions that were filed by Mr. Pryor on behalf of Mr. Daybell regarding motions to unseal 3 motions regarding prosecutorial authority, objections to motion to strike, and objections to states' exhibits in the memorandum until such time as the court may determine. What the heck does all that mean? Well, you have to go back even further. A motion to seal the state's objection to brief in response to defendant Chad Daybell's two motions on APA Smith, motion for discovery, and dismiss on the state's objections and briefs in response to defendant's Chad Daybell's motion to disqualify the prosecutor. Boy, that's a mouthful, right? Couldn't they just say response to the defendant's motion to disqualify the assistant prosecutor, Ms. Smith? That's what they could have said. That is a bunch of legal nonsense when we get into stuff like that. It is unnecessary, confusing, and they wonder why people don't trust lawyers when they start talking like lawyers. Just talk to the people like people, okay? Simple. It appears as though Mr. Pryor, on behalf of Chad Daybell, is still trying to get the prosecutors dismissed. Mr. Wood, as well as the Ms. Smith, who was brought in from the state of Missouri to assist in this particular case. I'll be honest with you. I went back and looked at Idaho Criminal Rule of Procedure to see what they could possibly be talking about. And it says any pretrial motions and objections or requests can be determined without the trial of the general issue may be raised before the trial by motion. The defense objects based upon defects in the prior proceedings in the prosecution. Well, but we don't know. We can't see the motions. And I got a real problem with this. Okay? This is a public case in the public arena. It should be made public. It's unfortunate if sometimes people are involved in a homicide case and there may be things that come out that are embarrassing. Well, guess what? It's a freaking homicide case. Okay? Sometimes people are going to be embarrassed. Privacy interest? You're a witness in a case. Yeah, we don't want your social security number. We don't need your location. But generally what somebody may say, I think, is generally open to a court file, and we should all have access to it. I don't like the way the state of Idaho seals everything at the quickest whim. The judge does have to remind everybody at some point that these are public proceedings, and it can't be public if we can't see what exactly is going on. So the only thing that I could possibly see is some basis that there's still a claim that there's a defect in the charging documents. But unfortunately, the judge has already ruled upon that issue, which was basically that there were defects before the grand jury. But the prosecution is saying he didn't raise them in time under Rule 12, where you can raise just about everything pre-trial. And so here we are. It'd be a lot easier to discuss, and I apologize if I seem like I'm somewhat rambling, but it's just so frustrating that everybody wants to talk in some coded language there in Idaho. Now, under Rule 12, also under 12D, motions under 12B, which is basically there's defects in the indictment, must be filed within 28 days after the entry of a plea and not more than 7 days before the trial, whichever is earlier. So I'm not really sure if that is what they're trying to argue. And it says in felony cases, motions under Rule B must be brought on for a hearing within 14 days after filing or 48 hours before trial, whichever is earlier. This case is set out for so long. We're coming up on 3 years already. Really, that's the best argument the prosecution has is, they didn't file within 14 days of filing of the indictment. Come on. The prosecution is the ones that kept saying that they needed additional time to prepare, and the discovery was voluminous. So there's your Lori Vallow, Chad Daybell update. There is a hearing set for the 15th. We will try to bring it to you, but it looks as though it's going to be, once again, sealed, so the public doesn't have any idea what is going on in this case of interest. We'll continue to follow it, and we'll try to decipher from the court's motions and rulings what exactly is taking place.
Like many Americans, we got a dog during the pandemic. My quarantine dog, Miss Winnie the Bulldog. Now, Miss Winnie has grown accustomed to being around us all the time. When we were leaving the house, Winnie would have extreme anxiety, so we decided to look for natural products to help with her anxiety. We looked for the highest quality CBD treats, and we were not satisfied, and neither was Winnie. So we created a high-quality CBD product that absorbs faster and provides the required results faster. Baked in Colorado CBD treats and beverage enhancers are made with nanotechnology. The nanotechnology makes the CBD extraction more pure, also allows for Baked in Colorado products to work faster. Baked in Colorado products can help reduce your pet's anxiety, ease joint pain, and help with your dog's skin problems. Go to our online store and see what Baked in Colorado product is best for your dog. When you order at bakedincolorado.com, enter code WINNIE and receive 15% off your first order. We have a 30-day money-back guarantee. If your dog does not experience the desired results in 30 days, return the product and we will refund your money. No questions asked.
Harmony Montgomery. That's the case of the young missing girl. Well, several law enforcement officers for multiple agencies have responded to Manchester, New Hampshire home in connection with the Harmony Montgomery investigation. Now, Harmony was officially reported missing by her mother in December of 2021, although Harmony had been not seen for 2 years. Now, court documents released earlier this year indicate that police received a call from Harmony's biological mother, Crystal Sorey, on November 18th of 2021, who claimed her daughter was missing. Sorey told police that Harmony's father had physical custody of the girl and she couldn't get in touch with him. Sorey added that she lost custody of Harmony in 2018 due to her own drug addiction issues. Adam Montgomery, according to Sorey, blocked her calls and blocked her from social media and didn't allow her to speak to Harmony after roughly Easter of 2019. Now, the New Hampshire police reached out to the New Hampshire Department of Child Services to locate Adam, but by December 27th, 2021, the agency couldn't find him either. Police began searching for Adam Montgomery when they learned that Harmony had not been physically seen since October or November of 2019. Police also spoke to Adam's brother, Michael, who said that Adam abused Harmony and gave her a black eye. Police then reached out to Adam Montgomery's cousin, a guy by the name of Kevin, who witnessed the alleged incident. Kevin told investigators that Adam was upset at Harmony when her infant brother started crying because he told her, Harmony, to keep an eye on him. In anger, Adam allegedly spanked Harmony, made her scrub a toilet with a toothbrush, and forced her to stand in the corner for hours. Well, this morning, the FBI, the Manchester Police, and the United States Marshals and the State Attorney General's office arrived at the home off of Union Street where Harmony's father, Adam Montgomery, and his wife, Kayla, once lived. So back in December of 2021, police located Adam Montgomery sleeping in a car in New Hampshire with his current girlfriend. The girlfriend told police that Adam never once talked about Harmony. Investigators interviewed Kayla Montgomery, who said she had not spoken to Adam Montgomery since roughly November of 2021, and that she hadn't seen Harmony since late of 2019. Adam told police that Harmony's mother came to pick her up in Manchester, New Hampshire around Thanksgiving in 2019 and he hadn't seen his daughter since. Police have stated that many of Adam's statements were inconsistent and secretive in nature. He'd reply with things like, "I have nothing to say," and "If I'm not under arrest, I'm not leaving," which are legitimate questions, not necessarily secretive, just saying. Now, Adam was arrested and charged with assault for the 2019 incident. Then earlier this month, he was charged with 8 more firearm-related charges. So far, no one has been charged in relation to Harmony's disappearance. Meanwhile, Kayla Montgomery has also been arrested earlier this year on fraud charges for allegedly continuing to collect government benefits for Harmony, even though she was not living with them anymore. In May, Kayla was also charged with receiving stolen firearms. Kayla was released on bail on May 6th of this year. Now, prior to the gun charge, prosecutors said they had made a plea deal with her on the fraud charges. The details of the plea were not released, but a hearing was scheduled for June 9th. The status of the plea deal is unclear considering the new charges. And the investigation is still ongoing, and we'll bring you the latest updates as they come available. Now, a couple of photos that were somewhat interesting was the fact that the police were unloading a refrigerator and taking it inside the residence that they were going to search. That obviously has new tenants in there right now. The police were also seen carrying in evidence preservation items that look like cans of paint, but they're like an aluminum can. So obviously they're looking for something. Now remember, for the police to go in, they either have to have A, consent from the parties that live there, or B, a search warrant. Now, one could possibly speculate, and I know we don't like to speculate here, but the reality of it is that, well, maybe the ex-wife, as her plea deal comes to fruition and she realizes that she could be going to prison for a long time on those gun charges, that maybe she thought it was time to come clean and help herself and probably provide some new information. Speculation. We will have to wait and see. All right, some more Amber Heard news. More clips from the Today Show interview with Savannah Guthrie dropped today, with Amber Heard admitting that she absolutely still loves her ex-husband, Johnny Depp. What do you think? Heard also hit back at several moments during the trial when she was called out for lying, including claims that she faked bruising on her face and allegations that she tipped off TMZ as to when she was planning to visit a courthouse in order to file a protection order against her ex-husband, now Johnny Depp. This broadcast marked the final installment of the 3-part interview that will be aired on NBC's Dateline on Friday. When asked whether she still loves her ex-husband, the 36-year-old actress replied, yes, absolutely, I love him. I love him with all my heart, and I tried the best I could to make a deeply broken relationship work, and I couldn't. I have no bad feelings or ill will toward him at all. I know that might be hard to understand, or it might be really easy to understand if you've ever loved someone. Despite the actress admitting that she still loves her former spouse, she once again doubled down on her allegations that he was the one that physically abused her throughout their relationship. Again, it is that thing. If you have bruising, if you have injuries, it is fake. If you don't have any, then you weren't injured, she said, of claims made by Depp's legal team that she faked bruises on her face and that she was seen multiple times in public in the hours and days after the alleged instance of abuse without any visible injuries. Heard went on to hit back at the criticism that she faced after it was revealed that she had not honored the $3.5 million donation or pledge to the ACLU that she insisted she had handed over from the $7 million divorce settlement from Mr. Depp, claiming that she had only ever meant to make the pledge over time. She also addressed her plans for the future, revealing that she now plans to be a full-time mom. Savannah asked about Amber's young daughter and how she plans to explain this situation to her one day. Amber says she's going to tell her the truth and be okay with it, knowing she did the right thing and she believes she's on the right side of history. And also yesterday, Heard's team was forced to deny rumors that the actress had been cut from her $2 million role in the Aquaman sequel. Just remember, every time Miss Heard doubled down and says that, just remember, every time Amber Heard doubles down on her allegation that her now ex-husband, Johnny Depp, assaulted her both physically and sexually, that is a new basis for another defamation claim. But she keeps doing it. What can you do? What do you think Johnny should do to Amber Heard? Go after the money that's owed, perhaps? Let me know in the comments below. Liar, liar, pants on fire. That is what a juror has said regarding Amber Heard's comments. And, well, one of the jurors that was actually on Amber Heard's jury says, hey, it's not like she said it was. First, the juror spoke anonymously to Good Morning America and slammed Miss Heard's recent claims. The male juror said that he and other jurors were uncomfortable with how Heard stared at them throughout the trial and that they struggled to believe her when she went from crying to being completely ice cold. He also denied Heard's claim that the trial was unfair because of social media. The juror said 3 of the 5 jurors don't even have Facebook or Twitter accounts. Now, Heard has repeatedly suggested that Depp only won the trial because he is more famous and more likable than she is. However, the juror said they reached their verdict based upon the evidence in the case. The juror said that the crying, the facial expressions, and the staring at the jury made them really uncomfortable. A lot of her story just didn't add up, the juror stated, and the majority of the jury felt that she was the aggressor. The juror even said some jury used the expression crocodile tears. The juror also went on to say that one of the turning points in the trial was Heard's admission that she had not donated her $7 million divorce settlement to charity, as she had claimed, and that she had stated publicly that she had in fact done so. He called it a fiasco and added that while Depp's legal team was sharp, Heard had sharp elbows and came off as abrasive. The juror stated she goes on that talk show in the UK. The video shows her sitting there telling the host that she gave all that money away. And the term she used as video clip was, I gave it away. I donated it and it's gone. But she didn't give much of it away at all, as the juror noted. And the juror also said, what I think is true is that they were abusive towards each other. I don't think that makes either of them right or wrong, but to rise to the level of what she was claiming, there wasn't enough evidence that supported what she was saying. So a couple observations. Obviously, when a defendant or a plaintiff or a criminal defendant in a criminal case go to court, one of the most important things you have to do is look likable. You're going to be sitting there most of the time, and if you start staring down the jury, guess what? You're going to make them uncomfortable. And you have to be nice, and you can't just be nice when you need to be nice. You have to look like a nice person all of the time. And when you're in trial for 6 weeks, you are not going to be able to pretend to be nice if you're not a nice person that entire time. And the biggest thing, jurors can understand mistakes, okay? They can live with that where mistakes are made, but the jury will punish liars. I've seen that in trial many, many times. And in a criminal defense case, when the jurors believe that the police were lying or that the prosecution was somehow trying to get something over on the jurors, and that goes for the defense as well, they will punish liars. And that's what the juror basically told Amber Heard. Your story didn't make sense. You lied to us. Why should we believe you? We'll see if more jurors come forward and defend the fellow jurors. First, Lori Vallow, Chad Daybell. As you know, anytime you have a death penalty trial coming up, there's a lot of work that needs to be done. Obviously, the prosecution has a lot of work to do to get their evidence, their witnesses all lined up to be able to prove their case beyond a reasonable doubt. The defense attorneys have a lot of work to do, not only preparing a defense, preparing cross-examination, any witnesses that they want to call, and then you also have to prepare for the death penalty phase, the mitigation phase, assuming the matter gets there. So all of the parties are rather busy. And it seems like prosecutors are looking for any reason to delay a trial. We know that Lori Vallow's attorneys would like a continuance. We know Chad Daybell's attorney is like, well, let's go, even though January's so far out, but let's do it anyway, anytime. Unless, of course, it's with Lori Vallow. So we have all those issues. But the other equation that you really don't hear about oftentimes in these matters is the preparation for the courthouse. And in this case, obviously, the trial has been moved up to Ada County. And while the Ada County Courthouse and their personnel are preparing for the trial for Lori Vallow and Chad to begin, which is in January of next year. And for those of you who don't know, the couple is charged with murder and conspiracy to commit murder in the deaths of Vallow's children, JJ and Tylee, as well as Chad Daybell's now late wife, Tammy Daybell. The courthouse is preparing for the trial after Judge Boyce ruled that the trial would be moved from Fremont County in eastern Idaho to Boise. Now, Daybell's attorney made the original request for a change of venue, arguing that significant media attention would affect the ability to find a fair and unbiased jury in Fremont County. The judge all but granted that motion, even though the prosecution put up a little bit of a protest. I think they knew the writing was on the wall. Well, another part of the reasoning for the ruling was so that the Ada County jurors would not have to be transported between the two counties for the duration of the anticipated multi-week-long trial. The prosecution requested that theory because they didn't want to be inconvenienced by being on the other side of the state. However, this case is still basically part of the Fremont County jurisdiction. So the Ada County Courthouse is essentially just providing them space and facilities and the local Ada County jurors to get this case completed. Now, while the trial is still several months away, preparations are underway for the courthouse. This includes ensuring that the courthouse facilities accommodate Judge Boyce and his staff that will be traveling to Ada County, and of course, working with the judge and the jury commissioner to ensure that potential jurors are summoned. Now, fortunately, Ada County has a large population, which means a larger pool of potential jurors. And Judge Boyce will have to decide if he wants to do a written questionnaire of jurors in advance. And court staff pointed out how much work it takes to get that questionnaire to thousands of people, to fill it out, then get them to fill out the response, and then return it to the judge and the attorneys for review. And because this is a capital case, the attorneys and the judge will have to find out where the potential jurors stand and would weed them out based upon whether they have a strong opinion on that matter. Now, the court expects a large turnout from the media, locally and nationally, so they're trying to figure out exactly where everyone's going to be able to park, and Judge Boyce is working on apparently trying to decide who from the press will be let into the courthouse. Their next big concern is the defendant, the jurors, the judge, and the witnesses, and that impartiality is maintained to ensure they are not exposed to media sources they shouldn't be exposed to. The actual selection of the jurors in a case like this, all potential jurors will not be together all at once. They'll likely be conducting jury selection in batches over several weeks to weed them out. I've mentioned this before, as I had a case once where there was a lot of publicity. We had a change of venue, and we brought in 600 jurors. And you literally bring them in waves. You have them fill out the questionnaire, which takes time for them to complete it. The judge makes all their introductory remarks. The attorneys then review it. You try to weed out who should be eliminated based upon those particular answers in there, in the questionnaire. And then you bring in the next batch. And then you bring in the people that have made that first screening, and then you try to talk with them to see if they are actually going to be qualified in a very general voir dire. In a capital case, I think it's always ironic that you really talk about the death penalty, the penalty phase, even before you've heard a single fact in the case, because for the jury to be death qualified, you have to have jurors that are willing to say they will impose the ultimate punishment if they follow the law. You have to get people out of there that will say, I will never impose the death penalty, because you're not a qualified juror, because you're saying I'm refusing to follow the law.